I am in two minds about making this video. On the one hand, many of you have given me very great, very generous feedback about my other defamation law videos and requested more videos on related topics, including updates on cases like Barilaro and Shanks. On the other hand, FriendlyJordies fans are quite painful to deal with. A recent video about the justification defence, which made the extremely bland and not in any way controversial claim that Mr Shanks had not accurately understood the truth defence, really came under fire in some corners of the internet because, after all, if you criticise FriendlyJordies, then you are unquestioningly accepting Mr Barilaro's view of the world. I should be really clear. When the litigation commenced, I didn't think that Mr Shanks had much chance of success. Now, he has one of the finest defamation barristers in the country arguing his case, meaning that I strongly suspect he'll still lose, but not lose by as much. The best defence available to Mr Shanks is blisteringly complex. It's called the Longy defence, ironically named after a former Prime Minister of New Zealand who successfully sued the Australian Broadcasting Corporation over alleged defamation. So with that as prologue, I figure that the safest way to deal with this problem is simply to give a trigger warning to the fans of FriendlyJordies. If you cannot handle the possibility that a man who sincerely believed that there was a satire clause in Australian defamation law might be factually wrong about the law, this video is definitely not for you. Go in peace. If, on the other hand, you're like, hey, a lot of the case isn't making a lot of sense to me, and I would be interested in getting a better understanding of the legal issues, then this video is for you. In this video, I thought I would tackle two of the big ticket items that have emerged in public debate. First, the public conversation about the jury trial is actually backwards. And second, there is a lot of misunderstanding about the parliamentary privilege issue. To the jury trial. You might be aware that the federal court has ordered that there will not be a jury trial in this matter. This very understandably got people quite upset. A trial by jury is one of those phrases that we associate with concepts of justice, natural rights, tricorn hats, Michelangelo paintings of God reaching out to touch the finger of Adam. Trial by jury has an almost mythic quality, a demigod in the pantheon of liberalism. My reading of the situation is that people were confused because they weren't in possession of all the facts. First, a lot of the mythology about the trial by jury relates to criminal law. Juries were a way to ensure community oversight of the criminal law system. It wasn't just legal elites who thought that I was guilty. I was found guilty by a jury of my peers. Reasonable people disagree about the utility of juries in criminal trials, and I think it would be unreasonable for a person to say that there weren't some systemic problems with juries. But that discussion is beyond us today. The key point is that we care a lot about juries for criminal trials, and even then, not all criminal trials. Barilaro and Shanks is a civil trial, not a criminal trial. Why is this a big deal? Well, here we have long-time neighbours Snugglepot and Cuddlepie, and they have a common boundaries dispute. Basically, Mr Cuddlepie here has a small parcel of land that he owns, but his house is built along the common boundary, effectively forming the fence line of Mr Snugglepot's property. There is a problem with the wall of the house. The mortar in the bricks is decaying, and water is leaking into Mr Cuddlepie's garage from Mr Snugglepot's property. Mr Cuddlepie believes that he has an implied license to enter Mr Snugglepot's property for the purpose of maintaining the wall. Mr Snugglepot disagrees, and so poisons Mr Cuddlepie's cat, Mr. Cuddlepie is like, what the hell, why did you poison my cat? And Mr. Snugglepot is like, what do you mean? I didn't even know you had a cat. But if you come on my property again, I will break your legs. And Mr. Cuddlepie responds, are you insane? I have an implied license to enter your property for the purpose of maintaining this wall. Water is coming into my garage, you maniac. And Mr. Snugglepot submits an initiating application in the magistrate's court to sue Mr. Cuddlepie for trespass. Freeze the story there for a moment. How would you expect this matter to be resolved? You would expect the matter to be sent off to mediation or something, yeah? Maybe somebody needs to work out the relevant common boundaries law in their jurisdiction, which differs across Australian jurisdictions, by the way. It's completely crazy. We should abolish the states. You would think it extremely weird if Mr. Cuddlepie was able to come into court and demand a trial by jury. It increases the costs of the litigation, it's a waste of people's time, and it's generally a nightmare. This is going to blow your mind, but there are some areas of law in which jurisdictions allow precisely that. And, yes, defamation is one of them. The Snugglepot and Cuddlepie scenario shows why most of the states and territories have radically reduced litigants' ability to access juries for civil trials. In the ACT, for example, no civil trial is held with a jury. Judge alone. In New South Wales, the only civil trials that tend to have a jury are defamation cases. In Victoria, the picture is more complex again. There is a category of civil law matters where a party can make an application to the court for the matter to be heard by jury, and then there is defamation law where the right to elect for a jury is actually in the statute. And this defamation law bit is basically the same in Victoria and in New South Wales. The bit about the ACT not having a jury for civil trials also applies to defamation law. Okay. How many jurors? Again, this is something that was not well understood in the public debate. It depends on the jurisdiction. New South Wales typically has 4 jurors for civil matters. Victoria has up to 8. In Barilaro and Shanks, Mr Shanks's barrister was arguing for a jury of 4 people. If you want a bit of a belly-feel intuition about juries and civil law matters, generally they are on the way out, with the exception of defamation law. Mark opinion time. I am dead against them. I really do not think we should have juries in civil matters. Media companies argue passionately in favour of them, claiming that juries are better at understanding the meaning of publications than judges. If only somebody around here was doing empirical legal research into defamation law cases. Oh wait, no, that's me. And I think this is one of those questions that has a lot of mythology built up around it rather than any shared set of facts. But all of this is mere piping to the big question. What happened in Barilaro and Shanks exactly? As we discussed in other videos, this matter is being held in the federal court. And what's the state of the law there? Well, we turn to Section 39 of the Federal Court Act, which says for civil trials, unless the court or a judge otherwise orders, the trial shall be by a judge without a jury. The starting point is no jury, but a judge can order otherwise. Now, one very learned author wrote a very good paper explaining Section 39 of the Federal Court Act and noted that the best way to interpret this section was to think of it in terms of exceptional circumstances. Ordinarily, no jury, but in exceptional circumstances the judge could order otherwise. Section 39 here should be read with Section 40, which gives more guidance about when a judge would set aside the usual practice and instead have a trial by jury. It says that the court or judge may direct the trial with a jury in any suit in which the ends of justice appear to render it expedient to do so. The paper then explored some of the arguments about how this provision should be applied to defamation cases, ultimately reaching the conclusion that there are institutional strengths of the jury system that should encourage their use in the federal court. Anyway, the punchline here is the author of this piece was none other than Justice Stephen Rares of the Federal Court, the judge currently hearing Barilaro and Shanks. Shout out to Michael Douglas from the University of Western Australia for drawing attention to this paper. There has never been a jury trial for defamation matters in the federal court, but at least one has been ordered. Kwang Suk Ra was a brothel owner who sued the Daily Telegraph and News Digital in the federal court over a number of imputations that they published, largely about sex slavery. The publishers applied under Section 39 of the Federal Court Act for a jury trial. The decision says that one of the great virtues of having a jury trial the substantial factual issues in a defamation action is that they represent the very audience to which the defamatory publication was addressed. In assessing whether or not a publication, first, is defamatory in the sense complained of, and secondly, has been defended under defences such as truth, honest opinion or fair report, a jury of ordinary, reasonable people is able to evaluate the competing factual issues, bringing to bear the moral and social standards that they share with the community at large. And they are better placed than judicial officers to assess how ordinary people understand mass media publications. Here's where things get a bit messy. The federal court was of the view that this defamation case went to moral and social values of the community, and that a jury would be better placed to decide those questions. I am less convinced that you would be able to get a jury of randomly selected Australians that did not carry prejudicial views about the sex industry. Needless to say, the court ordered a jury trial. Quite a large jury, in fact. The court ordered a jury of 12 so that any prejudicial moral views about Ms. Ra would be diluted. The judge here was none other than Justice Rares of the Federal Court, the judge currently hearing Barilaro and Shanks. Ra didn't end up going to trial. It's settled. To the best of everybody's knowledge, there has never been a defamation case in the federal court that has been heard by a jury. So, in Barilaro and Shanks, we start from the position that you don't ordinarily have a jury trial for civil matters. Mr. Shanks's lawyers submitted an application for the matter to be heard by jury. They had two key arguments. First, Mr. Shanks is an edgy online satirist whose audience is extremely online. Could Justice Rares, who has been on the federal court for 15 years, really understand the edginess of satire? Second, the core of the matter is fundamentally a moral and social one. To what extent should ordinary citizens be permitted to throw metaphorical rotten fruit at government leaders? Remember, Mr. Shanks had the burden of shifting the court on this one. His argument needed to get it over the line for a jury, and neither of these arguments was really a showstopper. In my view, the argument about the extent to which the ordinary people should be able to mock politicians was the stronger submission. The application was opposed by Mr. Barilaro's lawyers, and they had some very good arguments. First, Mr. Shanks had recently successfully organised a fundraiser in which he amassed a war chest of over $1 million. Mr. Shanks, it was argued, had an incentive to increase the costs of the trial, and remember, damages for non-economic loss in defamation law are capped unless Mr. Barilaro can demonstrate aggravated damages. So running up costs makes it more likely that Mr. Barilaro will have a Pyrrhic victory. Second, Mr. Shanks had recently encouraged attacks on the lawyers involved in the case and was actively trying to contaminate any potential jury pool. Given that the power under Section 39 is discretionary, it was argued that Mr. Shanks's behaviour made him unworthy of the discretion in his favour. Now, If I were the judge and I had a litigant that was engaged in repeated harassment of officers of the court, especially lawyers with very, very good reputations, then I would struggle to find it within me to use my discretion in their favour. Third, there were ongoing concerns about COVID and what the court might look like next year as far as court procedures. It's this final argument that has gained wide attention on social media. Mr. Barilaro, successfully convinced the court not to have a trial because of the New South Wales government failure to constrain COVID. But, as you can see, that's not accurate. The onus was on Mr. Shanks to convince the court to hold a jury trial. He didn't get it over the line, and he had stronger arguments against him than in favour of him. Some commentators from online news outlets, in my view, actively misinformed their audience and encouraged the belief that Mr. Barilaro was behaving improperly by convincing the court not to hold a jury trial, even though this is the default position, and that the court had acted corruptly or improperly by not granting the jury trial. Definitely, some of the commentary made it impossible for already agitated readers to form reasonable intuitions about the case. But this is a recurring problem with this case. It is also widely believed that Mr. Shanks has been forbidden to argue the truth of his imputations. This is not quite accurate, and this brings us to the question of parliamentary privilege. Parliamentary privilege is one of the big wins of freedom of speech in the Westminster system. Established long before the colonisation of Australia, enshrined in Article 9 of the Bill of Rights of 1688. As a society, we say that the deliberative aspect of Parliament is so important to our democracy that we will protect people who provide evidence to Parliament from threats of legal action. The Prime Minister could walk into Parliament and say, "G'day everybody, Mark Fletcher thinks that live-action DC movies are better than live-action Marvel movies, and my ability to sue the guy for trashing my reputation is basically non-existent." And if he can defame me like that without repercussions, think of what else can be said in Parliament. Head of a mining company is responsible for destroying Indigenous heritage sites. Shadowy figure is engaged in corruption and is undermining democratic processes. So-and-so is a person who has been convicted of a serious offence, and the court has unreasonably suppressed that information. Parliamentary privilege doesn't just protect parliamentarians. It also protects people who participate in parliamentary procedures, such as witnesses to parliamentary committees, for example. So what does any of this have to do with Mr. Shanks' defamation case? Let's start with the conclusion. Mr. Shanks was not permitted to plead a defence that would infringe parliamentary privilege. This makes intuitive sense, right? Parliamentary privilege is a big deal, and we as a society have said, yep, this is a safe space for free and frank exchange of views. You cannot use this protected material in your case, Mr. Shanks. Let's add some friction to this by looking at specifically what's going on. Mr. Barilaro pleaded, amongst other things, that Mr. Shanks defamed him by imputing that he is a corrupt conman and that he committed perjury 9 times. Mr. Shanks, in reply, says, "Yep, I admit that I said that, and it's defamatory, and also I have a truth defence." The usual practice here is that you outline the particulars that prove that what you've said is true. Instead, Mr. Shanks' lawyers said, "Trust us that we have a truth defence, but we can't tell you what it is because parliamentary privilege prevents us from doing this." This is a bit odd. You don't normally submit something that says that the other side has a privilege over the content of your materials. Instead, if you're going to contest it, you put it up, you then let the other side claim the privilege, or you don't put it up at all. Let's go in closer. Mr. Shanks expressed to the world, hey, Mr. Barilaro committed perjury 9 times. Mr. Barilaro sues for defamation. Mr. Shanks wanted to say, I can prove the truth of this, but I need to breach parliamentary privilege to do so. And then he also wanted to say something a little bit additional. He wanted to say, Mr. Barilaro knows that I can't defend the truth of that claim because of parliamentary privilege, and so it is an abuse of legal processes to sue me for defamation over this. The court rejected that argument, basically saying, hang on, you're the one who defamed Mr. Barilaro. You probably should have checked that you had a defence before you did that. And further, there are defences expressly so that you could engage in debate about what's going on in Parliament, but you chose to behave in a way that seems to have nuked your ability to use those defences. How is it Mr. Barilaro's behaviour that's unfair here? Here's how the court framed it. Rather, the unfairness lies in what Mr. Shanks seeks, namely to deprive Mr. Barilaro of the right to vindicate his reputation that Mr. Shanks attacked. It is Mr. Shanks's conduct, unprovoked by Mr. Barilaro, in doing what Article 9 prohibits from being justiciable, namely, in the Bruz video impeaching or questioning proceedings in Parliament, that created his own difficulty in pleading the substantial truth of what he said. That has resulted in the situation in which he now finds himself. I want to add one last detail to this picture. The privilege here is not for Mr. Barilaro to waive. There was a lot of commentary on social media that Mr. Barilaro should make this a fair fight by waiving a legal privilege that protects his freedom of speech. This was wrong-headed. The privilege is actually that of Parliament and not of the individual politician. Again, back to the decision. The critical factor to be borne in mind is that Article 9 creates a privilege of Parliament. The privilege is not that of a member or another person who participates in the proceedings in Parliament. The law cannot be that a publisher will be free to publish defamatory matter about what a member or other person who participates in proceedings in Parliament said or did, because Article 9 precludes the defence of justification. And the application of that statutory prohibition creates an unfairness to the extent that the court will strike out or grant a stay of any defamation proceeding or part of it that the person whom the publisher attacked commences. Such a consequence would turn Article 9 on its head and, instead, create a privilege for the publisher to defame the member or other person who would lose any right to redress in accordance with law just because of what he or she did or said in exercise of the absolute privilege in proceedings in Parliament. It would be an affront to justice if a publisher could choose to question or impeach proceedings in Parliament and, by doing so, create an effective immunity from suit by the member or person attacked. Such a result would convert Article 9 into an instrument of oppression. It would allow the publisher to be free to defame the member or other person with impunity, on the basis that any defence of the publisher's attack would infringe the prohibition in Article 9. That would leave the person defamed without a remedy that every other individual is entitled to seek from the court, however well-founded or baseless their attack. I understand that Mr. Shanks' lawyers are seeking to appeal this decision, but it is difficult to see them being successful here. So that is it for this one. I hope that the decisions make a little bit more sense. Like and or subscribe because it helps my metrics. Argue with me on Twitter @LegalReckoning, and I will see you next time. Bye bye.